Imagine you finally get the email you've been waiting months for. Your immigration case has moved forward. You filed everything correctly, you paid your fee, you signed your form, and you thought the hard part was over. Then, weeks later, a letter arrives. Not a request for more evidence. Not a simple correction notice. A denial. And when you read the reason, your stomach drops. It is about your signature. That scenario is not something imaginary. That is exactly the kind of situation that can now happen under a rule change from USCIS, effective July 10, 2026. And here is what most people still do not realize. This is not a small technical update buried in some government website. This is a real shift in how mistakes are punished, and it affects almost everyone who files anything with USCIS. Let's slow down for a moment and talk about what actually changed, because the details matter here. For years, if someone submitted an immigration form without a valid signature, USCIS would usually reject the filing. That word, reject, matters a lot. A rejection meant the form was sent back. You could fix the problem. You could sign it properly, resubmit it, and move on. It was frustrating, but it was fixable. Under the new rule, that safety net has changed. USCIS has updated its regulations, specifically the rule found at 8 CFR Section 103.2, to give the agency much more discretion. Now, if USCIS accepts your filing, and later determines that the signature was not valid, the agency does not have to just send it back for correction. It can deny the case outright. And in many situations, it can keep your filing fee, even though your case was denied. Think about what that actually means. This is not just a recommendation. In some cases, it is now federal regulation. A mistake that used to cost you a little time and a resubmission could now cost you your entire case, your money, and potentially months or years of progress in your immigration journey. This is where many people make a mistake. They assume signature rules are simple. Sign here, done. But immigration forms are signed by all kinds of people, in all kinds of situations. Petitioners sign for beneficiaries. Employers sign for employees. Parents sign for children. Attorneys assist with paperwork. Someone might type their name instead of physically signing. Someone might use a signature stamp. Someone might forget to date a form correctly, or a signature might not match what USCIS has on file from a previous document. In the past, these situations often got quietly corrected. Now, they carry real risk. And here is something else that surprises a lot of people. This change does not just affect one type of form. It touches almost every part of the system. That includes work permit applications, known as I-765. That includes green card applications, Form I-485. That includes petitions for family members, Form I-130. It includes citizenship applications, Form N-400. It includes employment-based petitions like the H-1B. If you are filing something, anything, with USCIS, this rule can now apply to you. So why is this happening now? USCIS has stated that this change reflects a stronger focus on what officials call filing integrity and procedural compliance. In simple terms, the agency wants fewer errors, fewer inconsistencies, and tighter enforcement of its existing signature standards. Officially, the rules about what counts as a valid signature have not changed. You can still sign your name by hand. You can still use an X or a similar mark if you are physically unable to write, including a fingerprint. You can still use a shortened or customary signature, if that is genuinely how you normally sign your name. What has changed is not the definition of a valid signature. What has changed is the punishment when something goes wrong. That distinction is important, and it is easy to miss. The standard is the same. The consequence is not. Let's talk about who is most exposed here, because it is not just individual applicants filling out their own paperwork. Employers are now under much more pressure. If your company sponsors visas, handles H-1B petitions, or supports employees applying for work authorization, your internal review process matters more than ever. A rushed signature, a missed date, an employee signing in the wrong section, any of these small oversights could now result in a denied petition instead of a simple correction request. For a business, that is not just an inconvenience. That can mean a valuable employee suddenly losing their ability to legally work in the United States, sometimes with very little warning. Families are exposed too. Petitions for spouses, parents, or children often involve multiple signatures from multiple people, sometimes across different countries. If one part of that signature process goes wrong, an entire family-based case could be at risk. And individual applicants, people filing for green cards, work permits, or citizenship on their own, are especially vulnerable, because many of them do not have a legal team double-checking every page before it goes in the mail or gets submitted online. What happens next surprises a lot of people. This rule does not just create risk. It also removes a previous form of protection. Before, if USCIS caught a signature issue after accepting your case, you generally had a chance to fix it. That built-in second chance is what has weakened. The agency now has more legal room to deny first and ask questions later. So what can you actually do about this? Let's talk about practical steps, because this is where the fear should turn into action. First, treat your signature the same way you would treat a legal document, because that is exactly what it is. Before submitting anything to USCIS, physically check that every required signature is present, properly formed, and placed exactly where the instructions specify. Second, if someone else is helping you complete your paperwork, whether that is an employer, a family member, or an attorney, confirm directly who is required to sign each section. Do not assume. Immigration forms often require the signature of the actual applicant, not just a representative, even when someone else is helping prepare the documents. Third, if you are an employer or part of a company's HR or legal team, this is the moment to review your internal process. Build in a specific signature verification step before any immigration filing goes out the door. Do not treat it as a formality. Treat it as a legal safeguard. Fourth, keep copies of everything you submit, including how it was signed and when. If a dispute ever arises about the validity of a signature, documentation on your side can matter enormously. And fifth, if your case involves any complexity at all, multiple signers, an employer sponsor, a prior filing, or a signature method other than a simple handwritten one, it is worth having a qualified immigration attorney review the document before it is submitted, not after a denial notice arrives. Let's bring this all together for a moment, because there is a lot to take in. USCIS changed its regulations, effective July 10, 2026, giving itself the power to deny, not just reject, immigration filings that are accepted but later found to have an invalid signature. The definition of a valid signature has not changed. The consequence for getting it wrong has changed dramatically. This applies broadly, across work permits, green cards, family petitions, citizenship applications, and employment-based visas. Employers, families, and individual applicants are all affected. And the biggest danger here is not the new rule itself. The biggest danger is not knowing about it until it is too late. This is not about panic. It is about preparation. Immigration law moves fast, and small procedural details that used to feel unimportant can now carry serious weight. The people who protect themselves best are not the ones who panic. They are the ones who stay informed, double-check the details, and take these small steps seriously before submitting anything. If you or someone you know is currently working on a USCIS filing, whether that is a work permit, a green card case, a citizenship application, or an employer-sponsored visa, please take a moment to check the official USCIS website for the most current signature requirements before you submit anything. And if you found this video helpful, share it with someone who might be affected, a coworker, a family member, a friend going through the immigration process. Small details like this rarely get the attention they deserve until someone learns about them the hard way. Stay informed, stay alert, and if immigration policy changes like this matter to you or your family, consider subscribing, because these rules are shifting quickly, and having accurate, practical information could make the difference in protecting your future in the United States.